Thank you, Mr. Starr, and thank you, Commissioners. Director, for letting me speak in advance. I'm chairing a meeting at 3:30, of which Supervisor Campos will be joining me, because until then, as you guys know, I will not be able to go to the bathroom until he helps us. So we will both try to fit within our time frame. Commissioners, thank you for providing me the opportunity to speak about my legislation before you today. I also want to recognize the Planning Department staff for their work and feedback on this legislation. It is an unenviable task to be put in this position, to comment on legislation and also a law that feels unenforceable as it stands, and moreover is legislation that the entire country is watching, as we are the second city to attempt to legalize and regulate short-term rental activity. But that also means that we should make every effort to make sure that we get the policy right, and as much as possible not allow politics to dictate this policy. We know that putting enforcement power in the hands of people work in limited situations when the public interest is important and the government simply does not have the resources to effectively enforce it. Preserving our finite affordable housing stock and reducing the potential unintended consequences of encouraging evictions so that the units can be used for more lucrative short-term rentals is of the public interest to this board, mayor, and the people of the city. We have not been able to demonstrate that we have the resources to effectively enforce this legislation. In fact, a few weeks ago, the Planning Department spoke loudly and clearly about the unenforceability of the legislation as it currently stands. I've said from the beginning of this debate around short-term rental legislation that as it stands, this legislation is not enforceable unless we add usable and effective enforcement tools. I know of conversation that came up a lot was around the issue of number of nights and hard caps. And an issue that I brought up, not in the legislation before us today, but I support, is the concept of a hard cap in any short-term rental policy. I think the question comes up, and you know this well, how do you prove where you slept last night? How do you even prove that you slept there 270 nights during the year? During our discussions in Land Use Committee, when this legislation came before us, I actually gave an example of something I experienced as a member of the school board. We have certain schools that are by testing and other types of admission, but we also require city residency in order to attend those schools. There are times when families may report on other families stating that they don't actually live in the city, county, San Francisco. I was very surprised to learn that the school district actually spends a lot of money and resources to investigate these cases. I will share two examples with you. We had an investigator knock on the door of a family at 7 in the morning to discover that parents and all the kids were in their pajamas, therefore proving that they lived in that address and were eligible to attend the school. There was another case where an investigator followed a female high school student on the bus all the way home to Daly City and found that her family did not, in fact, live in the address that they had indicated on their application. I just think that these types of investigations are incredibly expensive, but also incredibly intrusive, and is not the type of work that we expect our planning department to do. When the original legislation came before you last year, there was a backlog of 1,200 unanswered complaints regarding unlawful short-term rentals, and there were only 2 legal actions actually filed by the city. Those numbers alone tell us that we can't expect the city alone to effectively enforce this legislation. That is why my proposed amendment focusing on an expedited private right of action provision is in this legislation. It is narrowly tailored and provides nonprofit organizations whose mission is to protect or preserve affordable housing or tenant rights and have been in existence for at least 5 years. The tools to go after a limited set of egregiously bad actors, property owners and buildings of 3 units or more that are currently rent controlled. I appreciate the Planning Department's recommendation to approve this amendment in its entirety. I've heard concerns about this amendment that it may encourage drive-by litigation or that the city should be given the first chance to enforce a city law. So to address those concerns, we shaped the amendment so that we could target, again, the most egregious bad actors quickly. 1, the city is still the first line of defense against violations of this law and would be able to pursue civil relief at any time. Second, the nonprofits must have protecting or preserving housing in their mission statement filed with the state. Third, the nonprofit must have been in existence for 5 years so that anyone can't just start a nonprofit today for the sole purpose of suing tomorrow. 4, they cannot seek civil penalties or damages. They will be limited to attorney fees and injunction. There's no financial incentive to pursue this. They can only use the expedited route in rent-controlled buildings of 3 units or more. And eligible nonprofits will notify the city and planning department that they intend to sue to afford the city the opportunity to seek relief first themselves. This amendment is a result of compromise, and I just want to state now that there are 2 other proposed legislations around how a private right of action might work. I'll just say that I'm not supportive of limiting this tool to rent-controlled buildings of 3 units or more. At that time, that was a compromise that was forged in order to get votes at the Board of Supervisors. Now that this is an opportunity to evaluate 3 different ones, that is a piece that I would consider taking out. However, I do support the overall ability of pursuing the private right of action in this ordinance. PRA has been critical to enforcing many federal and state civil rights statutes, including laws that prohibit employment discrimination, police brutality, hate crimes, water pollution, immigration fraud, and more. The backlog, again, of 1,200 complaints on illegal short-term rentals is a perfect example about how a law can be meaningless without the tools to enforce it. A good example, though, of how this has worked at a local level is our hotel conversion ordinance, which is meant to protect our single-room occupancy hotel, a really important portion of our affordable housing stock. This ordinance wasn't effectively enforced until Quality Community-Based Organization won the right nearly 25 years ago in the 1990s to enforce on behalf of the public. And in the 25 years' time, there is no evidence that a single frivolous lawsuit has been initiated. Both the City Attorney's Office and DBI praise this tool and adamantly state that this ordinance has been effectively enforced due to partnering with the public. Most of us, another question that comes up is also the question of an expedited PRA. And most of us have been in an unhappy situation living next to an inconsiderate or outright bad neighbor. When one of us is in that situation, every day can feel like an eternity. Without my amendment, if you file a complaint with the city, you may be waiting 75 days or longer before you get to be heard by an administrative officer, and 105 days or more, which is more than 3.5 months before you receive a final decision. This was actually demonstrated last year when the tenants union filed 4 complaints in April of 2014, was finally able to get their hearing at DBI in June, at which one of the property owners even admitted to participating in illegal short-term rental. A final decision was issued in September, at which point DBI did not issue a single notice of violation because the plaintiffs in all those cases had temporarily cured their behavior. While the violations, we want to make sure that we don't allow opportunities for the violation to continue where you have zero recourse. And the resident in Russian Hill, who I remember spoke both to the Planning Commission in August and before the Land Use Committee in the fall, is a perfect example of someone who had been living next to a full-time vacation rental, often with fraternities and other parties, for 1.5 years, and it still hasn't been enforced against. Bad actors shouldn't receive months of free license to continue breaking the law before they're faced with real consequences. My private right of action amendment puts illegal profiteers who are tightening our housing stock on notice that you will have concrete consequences if you do break the law. Thank you for your time, and I'm available for any questions if they are on this piece or other aspects of the short-term rental ordinance.
Thank you. Any questions for Supervisor Kim? Okay, thank you.
Thank you so much, Commissioners.